Oh, okay.
It's the way it works. It's perfect, or you can't be there.
And Ira Raj is still our arborist here?
Retired as a colonel, and he was supposed to,
It's been a while since we've been here.
Congress wouldn't vote to extend his time in the service.
Oh, you can't be exempted.
I got James Ryan being here as of June 29th, 2023.
Told,
Yeah, okay.
I mean, November, December.
I was fortunate.
Right now.
No, we only have one today. And it's pretty.
Yeah,
I reflect fondly on my
Hour and
career
15 minutes
because
ago.
I was
Okay.
in command almost my,
and is
Same thing,
Brian,
5 o'clock.
I can't remember it.
Yeah.
It wasn't
Take the
it.
harvest at 6:20.
And now that I'm retired, I'm like, it's the last thing I
and
want
Miguel Hicks is no longer on the board.
I believe you
to do.
probably
Sitting here as the chairman and
We got
people, well,
Sylvia.
you should be the chair. I'm like, oh, fuck, no, I'm not doing that. No way.
So it was Holly.
Oh, is Holly sitting in
Oh,
the
there she
lobby?
is. Hi, Holly.
happy.
I have no desire.
I'm in charge of enough. No,
Hey, we get Holly,
Opinions.
at least for today.
Welcome to the red side.
I need an updated list from
Good, how are you? Happy New Year.
one of you guys.
Jeff. Are you sure you can fill that seat? I don't know.
Send a picture to him.
Comfortable.
Good.
The last one I have
Yeah,
had is
doing good.
April 18th, 2023.
I miss him.
Yeah, I bet. Not the same.
I know.
We couldn't get together this week for Taco Tuesday. I had a board meeting.
Conflict, okay.
But I signed up to do it. Are you doing it?
Oh, I thought we get rid of this.
Yeah, I'm gonna do it.
Very bad.
It was
Oh.
up from Largo
Oh,
3 or 4
really?
years ago, and I did it in
Packing
Largo.
me and they keep dragging me in.
I worked for Hillsborough County for 12 years, so.
Once you get sucked in, it's like tough to get away, right?
I know it is, you know.
Going through menopause, so,
Yeah, HOA
you know, she always
is one
constantly
thing.
reminds me, the temperature gets a little bit cooler
Now
than
I have
did she
Dealing with the
ever
water
want.
hose.
Oh, yeah.
included me and I've joined their organization. And I guarantee you, they're gonna want me to be the next president. I'm like, oh, God, no. But anyway, here we are.
Need to wait?
Yeah.
Presenting somebody?
Are you enjoying the cold? Oh, you do? You're not
With it up north, so.
But, that was it, okay.
hollering of it.
What about you?
Oh, did you? I
You
didn't
have to
even
go
see you.
stuff down there?
Were you on the same side of the street or the opposite side? You were? Oh, was that you in the hat?
You're,
Oh, it was cold and dark.
you're doing
Yeah.
stuff in Dunedin too, right? Yeah.
Didn't even recognize you. Sorry about that.
two.
Yeah.
Yeah.
Yeah, I know, right?
Well, if they don't have any business, they shouldn't be holding a meeting, right?
You call the meeting to order. You want to call roll, then we can introduce, and then I'll read the opening statement? Or you want me to do opening statement and
It's
then roll?
not dead. It ain't coming down.
We have to call roll first. Yeah.
There we go.
Easy peasy. Yeah, the one right there.
I wanna sit right here.
Mic's on? Everybody? Yep. Okay. Good evening, everyone. Call the meeting to order this January 17th at 6:30 PM. Happy New Year. Tonight, we also have elections to get through, but before we get on to that, we'll go ahead and do a roll call, and then we'll move into approving the minutes and then elections.
Okay, Beth Cardenas.
Here.
Carmen Lundy.
Here.
Holly Myers.
Here.
Christina Jackson.
Here.
Jeff Dahl.
Here.
Tom Shea.
Here.
Brian Heck.
Here.
Sylvia Maracus.
Here.
Thank you.
Wonderful. And I have minutes here from the last time we were together, which was October 18th. Can I please have a first motion to approve the minutes?
I move to approve the minutes.
I'll second.
Thank you very much. Chair recognizes Mr. Dahl and Mr. Shea as the second.
Aye.
All in favor? Sorry, sign it. Motion passes 7-0. I'll have to write that down. Okay, so next on the agenda, we have our elections. Mr. Trask, do you want to walk us through?
I'd be happy to. First of all, you remember that your rules of procedure that were adopted in 1991 are the same as they are today relative to election of officers. Section 1 of the rules provide that the board shall elect one of its members as a chairperson and another member as a vice chairperson. Section 3 of the rules provide that nomination of officers shall be made from the floor at the annual organizational meeting in December each year, and the election shall be held immediately thereafter. As you know, we didn't have a meeting in December, so that's why we're doing it today. So at this point, we just need nominations from the floor for chair, and then we'd move into vice chair after that.
I move to nominate Christina Jackson as the chair.
Second.
Are there any other nominations for chair? Okay, there being no other nominations from chair, then you will take over as chair again for the next following year then, okay?
Okay.
All right, the next, we need nominations from, on the floor from, or for chair, a vice chairperson to act in the absence of the chair.
I nominate Holly Meyer.
I'll second.
Any other nominations for vice chair? There being no other nominations, congratulations, Holly, you'll be the vice chair for the coming year.
Okay.
So the elections are complete at this point, we can move on to the next agenda item.
Thank you.
Congratulations.
Yeah, I know, right?
Okay, so at this point, I'm going to go ahead and read our opening statement. We've already called the meeting to order. Ladies and gentlemen, the City of Safety Harbor Code Enforcement Board is charged with conducting hearings to determine whether an alleged violation of the city code has occurred. In order to meet that obligation, all parties or their representatives will be allowed a full opportunity to be heard on all matters relevant to the alleged violation. All parties and their representatives or witnesses offering testimony or presenting evidence will be sworn to swear or affirm that the testimony they provide is the truth. The order of presentation will begin with the city presenting their evidence of the alleged code violation. The respondent shall then present their case following the conclusion of the city's presentation. Both parties shall have an opportunity to cross-examine all witnesses called by the opposing party. The board and its attorney may question any party or witness called to testify by either party. Upon completion of the evidentiary phase, both sides are allowed an opportunity to summarize their respective cases. The board will then openly deliberate, considering only the evidence presented, the law, and common knowledge. By motion, an order approved by at least 4 members of the board will be issued and within 10 days reduced to writing and mailed to the respondent. The order will contain findings of fact, conclusions of law, and affirmative relief to be taken. In a few moments, the code enforcement clerk will announce the names of the cases as listed on our agenda. When you hear your case called, please respond by coming to the podium with your representative and any witnesses to be sworn in. Okay, Mr. Bushy informed me that we have representatives for CEB 23051 and also for compliance, CEB 20006. Ms. Bandy, I'd like to make a recommendation that we move up 20006 to the first item under compliance.
Will do.
Thank you. Mr. Bushy, are you ready? Okay, Ms. Bandy, will you please call the first case?
Yes. I first would like to announce that case number 2 was on the agenda, has been continued. That's CEB 23-0249. We won't be hearing that this evening. But we are going to go into CEB 23-0351, City of Safety Harbor versus River Horse Investments LLC, 2044 Rainbow Farms Drive.
I need to go ahead and swear in the witnesses. Anyone that's going to testify in this case, if you can stand up, raise your right hand, I'm going to swear you under oath. Mr. Bushy? You swear that the testimony you're going to give is going to be the truth, the whole truth, and nothing but the truth? Okay, thank you.
Good evening. My name is Paul Bushy, Community Compliance Officer for the City of Safety Harbor. I am state certified in the fundamentals of code enforcement, administrative aspects of code enforcement, and the legal aspects of code enforcement. This case number 23-0351 involves the property at 2044 Rainbow Farms Drive, Safety Harbor, Florida. The city offers printout at the entry of this property from the Pinellas County Tax Collector's Office. Approval of the board. The printouts show the property is owned by River Horse Investments LLC. This is not a homestead property.
Any objections? The board accepts.
This case involves nuisances, specifically of Safety Harbor's Land Development Code, Section 153.05A. Permit required. Unless exempt pursuant to Section 153.03, it shall be unlawful for any person to cause any protected tree to be removed without first obtaining a tree removal permit. On December 8, 2023, in response to a resident's complaint, along with Safety Harbor arborist James Ryan, I investigated reported removal of 2 large oak trees in the front yard without the required permit. There was a tree removal company, Tree Technician, working and evidence of the removal, and there was evidence of the removals of the trees on site. Arborist Ryan determined that 1 tree was removed and that the other was so severely damaged that it had been effectively removed. Investigation showed no permits had been applied for or issued by Safety Harbor for the removal of these trees. In addition, the city has no record of documentation from a certified arborist or a Florida licensed landscape architect that the protected trees that were removed presented a danger to persons or property, consistent with Section 163.045 Florida statutes. Neither the property owners nor Tree Technician were able to provide such documentation. Our code is clear on the importance of and reasons for maintaining a tree canopy over Safety Harbor. Section 153 of the Development Code states, the purpose of this section, 153, together with Section 154, is to establish regulations in the city that have the effect of protecting, promoting, and maintaining a healthy, diverse, and mature canopy of native and naturalized hardwood and evergreen tree species. Trees preserve the ecological balance of the environment, control erosion, sedimentation, and stormwater runoff, provide shade, reduce heat and glare, reduce flooding, enhance property values and aesthetics, abate noise pollution, and buffer incompatible land uses. The removal of the protected trees would not be eligible for an after-the-fact tree removal permit because they do not meet the criteria to obtain a tree removal permit under Land Development Code Section 153.06. Specifically, 1, the protected trees did not pose a safety hazard to pedestrians or vehicular traffic, threaten to cause disruption of public services or utility services, pose a safety hazard to persons or buildings, and were not within the visibility triangle. 2, the protected trees were not weakened by age, fire, or other injuries, nor were they in major decline or have fatal communicable disease, a fatal and communicable insect infestation, or have defective structure that is a hazard. And 3, the protected trees were not removed to construct improvements outlined in Land Development Section 153.06A, 3, A through E. Section 162.09 of Florida statutes reads in part, if a code enforcement board finds the violation to be irreparable or irreversible in nature, it may impose a fine not to exceed $5,000 per violation. Because removal of these trees did not satisfy the requirements for a removal permit under Land Development Code 153.06 or meet the criteria established in Section 163.045 Florida statutes and cannot be replaced, the removal is clearly an irreparable and irreversible violation. Each of the 2 trees removed is a separate violation. Chapter 162.09 Florida statute states the board shall consider the following factors in determining fines. Number 1, the gravity of the violation. Number 2, any actions taken by the violator. And 3, any previous violations committed by the violator. In this case, the gravity of the violation is serious. The removal of the trees is irreparable and irreversible. Such large, healthy, and mature trees simply cannot be replaced. As for actions taken by the violators, there were none available due to the irreversible, irreplaceable nature of the violations. And as far as number 3 goes, there is no history of code violations by the respondents. The city would like to present an evidence photographs, copies of section 163.05 Florida statutes and Safety Harbor Land Development Code, section 153.06A, 1 through 3, A through E.
Any objections? Board accepts.
This first picture shows the trees in early September. I had the occasion to go out there in response to a neighbor complaint for the overgrowth and capture these photos at that time. The overgrowth was since brought into compliance or very quickly by the property owner. But I did use this photograph to show the board what the trees looked like before they were removed. You'll see the tree on the left and the tree on the right were both removed. That's the tree on the right. And the tree on the left, that's the way it looked when I arrived. Our arborist, Mr. Ryan, is here this evening and speak more about that if you have questions. But he determined that tree was effectively removed at this point, that it was not going to be able to recover the removal of the canopy.
Bushy, can you go back a slide?
See with the lighting, but I believe we still have a stump here and a 6 to 8 foot stump over here. Since been removed. And with that, I'd like to introduce Safety Harbor Arborist James Ryan with the board's approval.
Approved. No objections.
Mr. Ryan, can you please state your name for the record?
My name is James Ryan.
Pull the microphone down so we can hear you. Thank
My name
you.
is James Ryan.
Have you been sworn today, Mr. Ryan?
Yes,
What is your current position with the city?
city arborist.
Can you state any certifications you have for the profession?
I have a ISA certification and a TRAC certification. So TRAC is Tree Risk Assessment Qualification.
Thank you, Mr. Ryan. How long have you practiced in the arboricultural industry?
I've had an arborist license since 2019, and the TRAC certification I obtained in 2020.
Thank you. And are you familiar with the property located at 2044 Rainbow Farms Drive, Safety Harbor, Florida?
Yes, sir.
Thank you. And did you visit this property on December 8th, 2023?
Yes, sir.
Can you please tell the board about your visit to the property?
I arrived with Mr. Bushy to the scene you saw in the photos.
Did you speak to anyone?
We did, yeah. The property owner was there along with the tree company. So we spoke to both parties.
And at the time, did you do an assessment of the two trees?
So what I could see, yes, I walked up and looked at both.
And how did you identify the two trees as a live oak and as a laurel oak?
I did, yeah. So the live oak still had some canopy remaining. The laurel oak from the bark on the trunk and then the canopy that was piled on the side, it was obvious it was a laurel oak.
Can you describe the condition of these two trees before they were?
So nothing I saw indicated either tree was hazardous.
And live oaks and laurel oaks are protected trees under the Safety Harbors Code, correct?
Yes, sir.
And why are these two trees protected trees?
Mr. Bushy mentioned several reasons why they're protected trees. So live oaks and laurel oaks, they're both native trees, really storm-tolerant trees. They do a lot for the environment. They're on the protected tree list. That list is evaluated on a regular basis, so trees are added to it as needed. So that list is updated every year.
So the city takes protection of these protected trees seriously, correct?
Yes, sir.
Okay. And that's why they're prohibited from being removed under the city's code?
Yes, sir.
In your opinion, would the laurel oak and the live oak that were removed from the property qualify for a tree removal permit?
I'm sorry.
In your opinion, would the two trees have qualified for a tree removal permit?
No, sir.
And why is that?
Nothing I saw indicated they were hazardous.
Thank you. How did you first learn that the two trees had been removed from the property?
Mr. Bushy called and I believe it was reported from a neighbor and we went together.
Did you ask the property owners if they had documentation from an arborist certified by the International Society of Arboricultural or a Florida licensed landscape architect that the trees presented a danger to persons or property for the removal of the live oaks?
We did ask for the documentation, yes.
And did you obtain any?
No.
And did you ever receive a tree removal permit application for the two oaks that were removed from the property?
No, sir.
And so no permit was ever issued then?
No, sir.
Can you briefly explain to the board what a tree removal permit inspection entails?
Yeah, the permit is partially filled out by the applicant, and then there's a portion that I fill out when I go to inspect the site. So once I fill it out, when I visit the site, I determine if the tree is hazardous. If it is, I approve the permit, and we figure out the mitigation options. If it's not, I disapprove the permit and file it when I get back.
So is there anything that can be done to correct the removal of the two oaks without a permit?
No, sir.
So there's no after-the-fact permit or anything like that?
No, sir.
Thank you. In your opinion, is the removal of the two oaks irreparable and irreversible?
It is.
Why is that?
They're mature oaks, so both trees left in their life. They seemed healthy. What I saw indicated that they were healthy trees.
In your opinion, how severe is the violation?
Trees are gone. I think that's as severe as it gets.
Thank you, Mr. Ryan. That's all the questions the city has for Mr. Ryan, but he will be here and available to answer any questions from the board.
So at this point, we can ask both questions since we let him come up, Mr. Bushy or Mr. Ryan? You're not done? Okay.
My suggestion is let them finish their testimony. They may be able to answer your questions before you even ask them if they finish their presentation.
A notice of violation was mailed, USPS certified, return receipt requested, notifying the property owner of the violation on December 20th, 2023. The notice included information that the violations are irreversible in nature and cited the appropriate code sections. The city offers the notice and the USPS proof of mailing in the evidence with the board's approval.
Objections? Board accepts?
On January 5th, 2024, more than 10 days prior to today, Code Enforcement Board Clerk Elizabeth Bandy mailed a notice of hearing to River Horse Investments, LLC, USPS certified. A copy of this notice was also posted at the property, and an additional copy was posted at City Hall. The notice cited the appropriate code section and the date of the hearing. The city offers the affidavit posting, the notice of hearing, the USPS proof of mailing, and the evidence of the board's official.
Any objections? The board accepts.
The property remains in violation as of this morning, January 17th, 2024. Administrative costs to prosecute include at least 9 hours of the city arborist and code compliance officer's time, and at least 16 hours of the code enforcement board clerk's time, for a total administrative cost of at least $410. The city asked the code enforcement board to find the property owner, River Horse Investments LLC, in violation of Safety Harbors Land Development Code, section 153.05A. Staff recommendation is in addition to the prosecution costs of $410, and since each tree is a separate and irreversible violation, the city asks the code enforcement board to find each removed tree a violation and award the city $5,000 per violation, for a total of $10,000 plus $410 in administrative costs, for a grand total of $10,410. Thank you.
That concludes your testimony.
Thank you.
I have a couple questions using your demonstrative aid, exhibit number 2, slide 4, and slide 12. If you could please pull those back up. This one. Mr. Bushy, do you have any idea how close this tree trunk is to the house? When you were on site, did you happen to?
I didn't take any measurements. It's relatively close, though.
And it's the same question for slide number 12.
That one appears to be a little bit further away.
Thank you. No further questions for me.
Thank you.
Any questions for Mr. Bushy from the board?
Be clear on the progression. There was no work stoppage at this point on the day of?
No, I consulted with Mr. Ryan on that. He said, no, that tree needs to come down at this point. It's already destroyed.
Thank you.
Any further questions for Mr. Bushy or Mr. Ryan? Okay. If you wouldn't mind.
Cross-examination.
Cross-examination at this time. So you may come forward, yes, and give
Sure.
your testimony, and he's been sworn in.
Yes, he has. Sir, if you could state your name.
My name's Eric Babe. I'm with River Horse Investments LLC. I asked Larry Harkins with Tree Tech, the company that did the tree removals, to join me this evening.
All right, I'm going to stop you just for a second. Now is your opportunity to ask questions. We called cross-examination of Mr. Bushy and Mr. Ryan, the arborist. Do you have any questions of them before you make your presentation?
Actually, it's sort of in the middle, but I can do that. I can actually ask them in the middle. And if I may, Mr. Ryan, correct?
So, Mr. Ryan, we need to get a microphone to you, so.
This ties in well with what you were just asking. Did you say, or you did or did not measure the distance between the house and the base of the tree?
We did not.
And from the photos that you just observed, would you, how many feet would you estimate the trees are away from that house? Estimate.
So the laurel oak is probably, live oak, it would be a little bit harder to tell, more than that.
So a laurel oak with a 22-inch diameter, approximately how old would that tree be?
It would be, there are so many factors.
22-inch diameter laurel oak, on average, how large would the tree canopy be?
It's impossible to tell, they range so drastically.
Observing the photos, can you estimate roughly how large that canopy is?
No.
Would you say, in your your expertise that the root structure of a 22-inch diameter laurel oak would extend more than 3 feet beyond the base of the trunk?
Yes. In the direction where it's unobstructed, yes.
And would you say the same thing for a 26-inch live oak?
Yes.
So is it fair to say that the root mass of those two trees would extend beyond and to and under the foundation of that property?
I couldn't tell you that. So it depends on when the tree was planted, when the foundation was put in. Generally, roots want to stay very shallow, 18 inches, 24 inches deep. If a root hits a foundation, it doesn't want to go under it. They want to grow where their conditions are favorable, where there's water, where there's oxygen. So generally speaking, the roots won't encroach under the foundation.
Can you repeat that one more time?
Generally speaking, roots will not encroach under the foundation of a home. They want to grow where conditions are favorable.
Those are all the questions I have.
Okay, all right. So now you have your opportunity to present your case, call any witnesses that you like.
We asked Tree Tech to attend this evening because obviously they're the ones who have removed the trees. And I don't disagree, this is irreparable. All right, we can't replace those. I wouldn't say it's irreversible because one of the things we are prepared to offer at a time and place and location the city's choosing, we will go plant 24 new oak trees. These trees cannot be replanted on this site, and as I'll show you here in just a minute. And before we go any further, it is not, was never our intention, either Tree Tech or River Horse, to circumvent this removal process, the permit process. We always intended to remove them, but not circumvent the permit process. Mr. Harkin, there's two entities involved here. It's not just the owner. We have a demolition permit, open demolition permit with Safety Harbor. It was his understanding that the trees had to be removed before the demolition could begin, and that was accurate. But he misunderstood that they were going to handle the permit process of the tree removal. He thought it was all inclusive. We have a partner in Pennsylvania, we have myself, we have the AAA services out of Clearwater, and the tree removal company. And that is literally just a misunderstanding. He was hastening to the site to get it done. We put him under pressure to get it done quickly, and he just didn't re-verify that the permit process was indeed not his responsibility, and it was, and he's here to confirm that. But it wasn't done maliciously, so he said. I'm gonna put it that way. So to the point you just raised, and you know, it's pretty obvious from the photo, the one tree measures exactly 2 feet from the slab. The other tree measures 5 feet from the slab. That's the distance. And by the way, the holes are still there, so it wouldn't be impossible or impractical for an arborist to go remeasure. There's also a root mass there, which I'm pretty sure would also indicate exactly how close those were. So I'd like to ask Mr. Harkin some questions. Similar question. All right, I've reviewed these tree charts. The tree canopy on a tree that's 30 years old, roughly how large would that canopy be?
It's very hard to tell, like James said, depending on how favorable the soil is around the tree, depends on how large the tree will get. Problem with that tree is it's cracked foundation, and the tree needs to be removed in order to demo the house. If you were to try to demo the house with the trees there, James is familiar with soil compaction. The machinery that's going over the root systems around those trees would have severely stressed those trees and most likely killed those trees.
So a preservation zone around the trees might have protected it?
Not on a tree that size. The tree preservation zone would have been too large in order to demo the house.
So a preservation zone around either of those trees, demolition equipment wouldn't have been able to navigate without damaging the
It would have
roots.
broken the canopy on the top and caused severe damage to the tree, which would likely kill the tree.
Recommended distance for an oak tree from a house is 3 feet, 20 feet?
I wouldn't put it any closer than 15 if it were my house. I mean, I understand the root systems of the trees usually go out to the drip edge of the canopy, which means they extend fairly far.
And so would you agree or disagree with Mr. Ryan's statement that the root mass of these trees would not have gone underneath that foundation?
100% that's undetectable, but I have seen a lot of foundations crack because of trees. And in that case, in that tree, or in that home, the windows were not, you weren't able to actually open or close the doors without prying them open because of the structural damage of the foundation because of the tree.
To Mr. Harkins' point about foundation damage, Mr. Bushy, if I may, as you have a photo of the slab damage that was readily available to Mr. Ryan the day that he was on property that shows the cracking of the slab 3 feet away from that tree. Oh, you have it.
Mr.
Great.
Bushy, any objections? You've seen it? No. Okay, the board accepts.
Oh, sorry. I have 100 photos, but I know you all have other stuff to do tonight, so I won't go through every single one. The first tree is approximately 4 feet to the right. The second tree is approximately 4 feet to the left. And that is one of many. And another one, this is interior. This is 3 feet inside the front door.
Any objections? Board accepts.
You see the wall literally buckling. This house has been vacant for almost a decade. Back in 2007, the then owners received a repair estimate in excess of $300,000. Every single wall, ceiling, slab within this house has been damaged. And these oak tree roots did it. There was an argument made at one point that this was from settlement. Safety Harbor knows well about settlement. But in this case, we had a geological survey completed, and that geological survey showed that there was no subsurface activity. This was all root mass causing these damages. And I'd like to enter, if I may, 2 pages documenting the damages from 2007. And I only share that to share this. It's been 16 years since that estimate was done, and those damages were shown. These damages are from last year. But in 16 years, the root mass just continued to extend.
Any objections, Mr. Bushy?
Mr. Bush, you have no objection to my other point.
Second.
Board accepts.
To my other point, this is the geotechnical exploration results, evaluations based on our review of the soil test borings. We did not encounter any type of subsurface subsidence activity.
Any objections?
There was sinkhole activity. There might be another explanation for the amount of damages that were caused to this property, which then takes me to something that's been said twice now, which I don't believe is accurate for this reason. You referred to Chapter 153 of the Land Development Code. It provides for an after-the-fact permit. Both gentlemen have stated that this property would not be eligible for an after-the-fact permit, and I would submit that it would in fact apply because since trees represent a safety hazard to persons and buildings through the documented damage to the structures, foundations, walls, and ceilings. So I don't see how it could be determined that it's not a danger. No one can even live in this house. The walls, slabs, ceilings are all cracked and falling in. Neither one of these, obviously they're certified and experts in their field, but they're not general contractors, they're not engineers, and had they entered the property, they would have seen that this damage was caused, one, by the oak trees, but two, more importantly, it was in fact a safety hazard to persons, and certainly a hazard to the buildings because they've been destroyed. The second thing, and maybe even more important for the rest of the community, is, and they wouldn't have known at the time because we hadn't called 811 to mark utilities, but along the front of the driveway, and if we could have that photo back, actually, I think it would be great. Can I show you that for that, Mr. Bushy? I know, I meant that slide too. Right, actually, that works great. If you see the location of that one skid steer, once it was marked, the underground power line for that neighborhood runs right underneath that skid steer and across the front of the house, as does the water line, as does now Frontier Cable. Those oak tree roots extend into that because as those stumps were being removed and the concrete was being broken up, you can actually see how far those root masses extended. So to the point that it wouldn't apply, we wouldn't qualify for an after-the-fact permit, I would submit that in accordance with 153.06.1, that it is a danger to public services and utilities due to the underground lines that are running right there. Last thing, and unfortunately I can't document this, I can't document it, but Mr. Harkins is here. The 26-inch live oak, while there were, I'm not an arborist, but in his mind there were signs that it was in decay. Mr. Rhines testified it was not in decay, but once that stump was removed, you could see on the inner core it was already starting to rot out. And part of the reason, as you noted, it couldn't grow any further because the slab in the house was keeping it. And it was not healthy. Unfortunately, again, I don't have that. Yeah, okay. The last thing, you've already brought up the point about the heavy equipment compaction. These trees would have died anyway when we went through the permit process. But it's not like we didn't want to do this. That's why all those other oak trees that you see, those are all on that same property. This was never about destroying the tree canopy, which is why we're more than happy to go put 24 oak trees wherever you want them. We'll pay the $410 even. But you can see there's a permit, I believe it's P240016 is the demolition permit that we applied for. And Mr. Harkins know that he didn't have responsibility for that permit, none of this would have happened. We still would have filed for the permit, we still would have needed to pull these trees. We could have probably done a better job at documenting the one was already in decline. And would the city have said, no, you can't remove the two trees that just destroyed your $500,000 house? I mean, I don't think that would have happened. I appreciate it.
Okay, hang on there, sir. So any questions from the board members before cross-examination?
I do have one question. Looking here at the report that you have submitted, exhibit number 2, the Florida Public Adjusting.
Yeah.
It's 3 pages, signed by Tim Zeke.
Yeah, it's much longer than that. I just cut the pages so you can see that each one of those pages show slab and wall damage.
And it's dated March 27th, 2007.
That's how long ago that damage began, yeah.
Yeah. In the second paragraph, it mentions that it's one of the worst cases of sinkhole damages that they have seen.
Yeah, that's a great point, which is why we took the geotechnical report, which I just provided a copy of, and because it was obviously we were going to have our investment group take this property down if they had sinkholes, so we brought in another company. If you've been in Safety Harbor any length of time, or you've been in Pasco County or done real estate or construction there's been so much sinkhole fraud. It's part of the reason why insurance rates rose the last time they did. This time it's roofing, but back then it was sinkholes. There was no sinkhole, there was no subsurface. Whether that was his uncle or his brother, I don't know, but that wasn't the cause.
No further questions?
And I would refer to the most recent geotechnical report as the basis for that.
I have 2 questions.
Okay, Chair recognizes Mr. Dahl, and then
Mr. Bade,
Yes.
you said
Fire and then-
that those 2 trees' roots caused the damage to the house. That is your testimony, is that correct?
It is, yes. And I don't say that, I'm not a certified arborist, but I've been in real estate, construction, and mortgage in the Tri-County area for 30 years. We do property renovations, we do new builds, we do commercial, and I from my 30 years of experience, that's from root damage. And the location of the damage, as you walk into the house, it's not just coincidental that all those cracks in the ceilings, walls, and slabs happen to run right along where those root lines are going. When those stumps came out, and I'm sorry I don't have a photo with me, when those stumps came out, when the root masses came out, they were literally 2,000 pounds, and excavators couldn't move them, they had to be cutting out. They were literally wider than my arms, and that was just the mass from the ball of the trunk.
May I share a story with you?
Please.
yeah.
No stories. Questions?
Afterwards.
You can include your comments, when you get to the motion and address it.
will.
Okay.
And I will.
Okay.
Thank you. I have no further questions.
Chair recognizes Ms. Meyer.
Is this your first time doing a renovation in Safety Harbor?
In the city limits, yes, which is why we retained an experienced arborist and an experienced demolition company.
So you're not familiar with how sacred the live oak trees are in Safety Harbor?
Absolutely. I grew up in South Tampa, it's just as sacred there.
Okay. And are you planning to actually repair this house, or are you gonna demo it?
Demolition. AAA Services out of Clearwater is handling the demolition permit that's now open in the city of Safety Harbor.
So in reality, the whole house is coming down?
It's not,
And-
right, the estimate that I provided from '07 was over $300,000. The current estimate to repair that house is over $500,000. There's no way to save it.
Okay, thank you.
Chair recognizes Ms. Lundy.
Yes. For the sake of what Ms. Holly was asking, that you had planned on the house is coming down. So if the house is coming down, then why was it so important what the roots are doing to the house, first of all? And the second question is, did the demolition permit, as you say, gave you leeway to take down these trees?
I'll clarify that point first. No. Mr. Harkins thought that the demolition permit would include the tree removal. So he thought we had already handled that. That's why he didn't go pull a permit. He thought it was already being handled as part of the demolition. And to the first part, the only reason I bring up the tree root mass destroying the foundation is that as it relates to the claim that this wouldn't apply for an after-the-fact permit. An after-the-fact permit would only apply if there was a danger to public and or property. In this case, there is danger to the property and persons living there if they did, because of what the trees have done to it. That's the only reason I bring the roots up.
And because you made such a great case of it, it led me to believe that was your case to plead a purpose of why you did, because of the damage it was doing to the house, where you're also saying we were taking the house down anyway.
No, I'll go back to what I said right in the beginning. It's irreparable, not irreversible, or one or the other, pick one of the words. We can't put those 2 trees back, but we can go plant a whole bunch of oak trees. And we're happy to do that, right? This is a mistake. This was a communication mistake between the 4 entities working on this. This is not to avoid the permit process for the tree removal. Never the intention. The intention was the demolition of the property. He would pull a permit for that, AAA would pull the permit for the demo, and it would be done in that order. Jump the gun on the first part. That was the ultimate goal anyway, to have both of those trees removed. One, they wouldn't survive the demolition to begin with. One of them was already dying. They had clearly destroyed the property. And because of how many other oak trees are there, there's a limited space for a new home to be built on there. If we were to have left those and put a new structure right there, the same thing would have happened. Or it would have killed the trees anyway.
And you know what? I respect what you're saying, and I understand the conclusion of what you're saying. But I'm just gonna be real with you. It just sounds like the justified reason. Because you're saying the tree was gonna be harmed anyway after the fact, but you know you had not thought of that at that point. Am I correct?
Can you hold the mic up, please?
Soil compaction on those root systems of those trees is very serious. I'm not certified through the ISA, basically because I've worked for myself after working for Asplin at 16 years old. And as a contractor down here, I've pulled permits in Safety Harbor before through Art Finn that used to be here. I was on his list of reputable licensed arborists, just not through the ISA arborist, because ISA has declined me 3 different times saying my application is incomplete because I have not had management skills through so and so and so contractors to prove to them to let me take the test. But I know the book inside and out. And you're not gonna bring dozers in there and not damage those trees. Once they compact that soil, those trees are gonna be heavily stressed and most likely die. But chances of survival, slim. As far as dying, high.
So you're saying you were doing the trees a favor by taking them down because they were gonna die anyway?
Well, if I was a person out here, slaying trees down, putting up townhomes, and I was Bowens or Stevens, Danny's Tree Service, may get a pass. We were just out there trying to make an honest buck, and as far as I can see, I'm all for the trees. I understand their importance to humanity and our environment. But when someone's replacing a whole home, chances of those 2 trees surviving with bulldozers going in there ripping all of that stuff out are slim to none, in my opinion. And that's my opinion only. But I'm very familiar with the International Society of Arboriculture, and I've done my homework. And if they ever let me take the test, I can almost guarantee I get a 97 or above. So we were just trying to put some work on the board in the slow season and get these guys paid so I don't lose my men. We did an excellent job. Satisfied with the job?
Well, it wasn't excellent that the permit wasn't pulled first, but that's, I mean, to your questions, Ms. Lundy, there's two completely separate things. The trees would not have been pulled down had he known that the tree permit wasn't part of the demolition permit request. This is one extra entity, and wouldn't have happened. And had I known he was already out there doing it, or heading out there that day to do it, would have said, don't go yet, because the permit's not done. That's it.
I've pulled permits in the city of Safety Harbor before. I've taken Alan Mayberry's class, I've pulled him in Clearwater, I know Dave Riley, the ex-arborist that used to be in South Tampa. I've pulled permits in every single county around here. I know Art from when he used to work at Dunedin, I know Dennis. I'm not out there just ripping trees out of the ground for no reason. That's not who I am. That's not how we do business. You know, we used to do some stuff back in the day where arborists, I would have our climbers that would lion's tail the tree when I wasn't familiar with the ISA, and now I am. And a tree, or two trees that are in front of the building that's being demoed, that are 3 foot away from the building, maybe 5 foot away, that's kind of like a no-brainer. They're not gonna make it. They're not gonna survive.
I wonder if Mr. Ryan could comment on that, to validate that those trees would not have survived the demolition. And the demolition, there's no other course of action for this building. It's not livable.
I think you've answered the questions. Any other questions from the board?
Do you-
My question was answered. I think I'm good. Appreciate it.
I have one additional question for you. Bade, is that how you say your last name, Mr. Bade? The question, 24 trees anywhere in Safety Harbor, why 24?
Oh, that's a great question. Well, these were both 20 to 30 inches in diameter, and your ratio is a 3 to 1, and there's 2 trees, so that would be 12. And so I'm just trying to gesture of goodwill. So I took that number and I multiplied it,
What would that investment cost you?
probably $2,000.
Total or per tree?
Well, we have equipment, and so between our equipment and Larry, then, you know, we purchase the oaks, we go dig the holes. You tell us where, when, we dig the holes, plant the trees, get them wholesale.
So $2,000 for up to fines of $10,000 is what you're facing in your
Well, we're
evaluation?
facing fine- Yeah, and part of my argument that these trees were gonna die anyway is that we're gonna get fined $10,000 for removing trees that would have been removed anyway during the demolition process.
No
Or
further,
would have died anyway. Let me rephrase it, would have died. It's-
thank you. No further questions from me? Any
Hang
other
on just a second
questions?
now. Any cross-examination from the city?
We have one question.
And-
See a microphone. Thank you. So during your testimony, you referenced the demolition permit a couple of times. Was this applied for before or after the trees were
After.
removed? Okay.
So Mr. Hart,
That's our only question. Thank you.
And for the record, it's Larry Harkins,
Lawrence.
Lawrence.
yeah.
Okay.
Lawrence Carter.
Okay. Okay.
No, summary from both sides?
Yep.
Yep.
Would you care to do a summary? Okay. Thank you.
The respondent is cited with having violated section 153.5A of the city code, which reads, unless exempt pursuant to section 153.03, it shall be unlawful for any person to cause any protected tree to be removed without first obtaining a tree removal permit. That means that if a protected tree was without a permit, there's a violation. Acknowledged that the trees were removed without a permit. The board heard the city arborist's qualifications in his determination that the removal of the tree would not have been granted a permit, either before or after the removal. If the board found the city's testimony credible, it should find the respondent in violation. Thank you.
Thank you. You may come up for summary.
I mean, $10,000 is a lot of money. But from a legal standpoint, The only reason we would not be entitled to an after-the-fact permit is if you were to determine that that structure is not a danger to the public and/or the structure itself. It's, the pictures clearly show how close those trees are. The damages, you have 2 photos, but you could get more. The people that work for the city have access to go verify this themselves. It's a physical danger to persons or structure. An after-the-fact permit is a legal option. And 2, the utilities run right in front of that root mass as well. Public services are one of the reasons that an after-the-fact permit would be granted. And if an after-the-fact permit is granted, then a fine wouldn't apply. That's our summary.
Thank you. Okay, summary is complete, no further comments, no public input. At this point, I'd like to make,
I'll do it.
thank you, Mr. Dahl.
I move based on the testimony and evidence presented and based upon these findings as a matter of law, that at the time of the alleged violation of section 153.05A of the Code of the City of Safety Harbor was in force and was in effect. A fine of $8,000 shall be imposed on the respondents in this case, and an award of $410 shall be awarded for the cost incurred in the prosecution of this case.
Second the motion.
Following our rule of orders for Ms. Marakis, the person who makes the first motion has the right to converse first with the
Thank
board.
you. I would love to talk.
Yeah.
I have a 450-year-old southern live oak in my front yard. I love it second only to my spouse. It has never impacted my foundation. It has never impacted my driveway. I have no damage whatsoever. I find the testimony of the respondents unbelievable, because I sit on a 450-year-old southern live oak, and it's less than 10 feet from my house. I have nothing further to say.
Okay.
I have no additional comments.
Okay, any further discussion from a board member?
Just to piggyback off that, did you read somewhere, and I may have missed it, that the damages structure to that house had something to do with sinkholes?
Yes, in the initial report
2007 report.
that was submitted by the respondent.
Can you give some commentary, Jeff, on why the 8,000 as opposed to the max of 10,000?
If the respondent agrees to plant 24 additional oak trees in the city of Safety Harbor, I lent $8,000 so that he could then use $2,000 to plant additional shade trees in the city of Safety Harbor.
There's no accountability to follow through
No,
on
there
that
is not, but
gift.
I'm going on his word.
Let me just be, try to be middle point here. Would it be what we think considerable to see if they, because he made the point that almost he feel like guaranteed he can get this after permit. Would it be considerable for us to allow that sometime? And let the city make that determination and then make a ruling?
I thought we heard from the city that it would not be eligible.
I thought
after.
so too,
I
that it
think
wouldn't have
that's
been
a dead end.
eligible. I'd have to pull the code to read. And I also thought that fines could be contested at a higher level, can't
Because
they?
he was talking about 153, he was talking about 153.6.
53.061 you referenced.
And I think at this point, he had that opportunity. He, that we know of, did not take it. And at this point,
There's no way to prove that the trees were problematic because obviously at this point they're gone.
Hard for an arborist to evaluate.
And the point that, you know, there was the document provided by the respondent that said the damage in the house was caused by the sinkholes. It's clearly up for debate, so I don't know how he would prove that to get an after-the-fact permit at this point.
They also did an after-the-fact permit for the demolition permit. Did you hear that as well?
No, it just hadn't, it was filed after the trees were removed, right? Right, so it wasn't even considered as far as that process was going, yeah. It's a process issue at that point, right? It should have been done first.
Mr. Trask, I have a question for you about the 24 trees and about the motion that stands today. Does that need to be amended to include the 24 trees?
The motion is just for the $8,000 and the $410 in prosecution costs. There's no obligation by the property owner to install the trees. And frankly, you don't have the ability to make them do that.
I mean, if we're comfortable at the 8,
I would make a motion to do the 10,000, just on the premise, you know, the Monday morning quarterbacking doesn't negate the fact that they totally disregarded the process to get the permit in the first place. He admitted it was a mistake. He admitted they were in haste, so haste makes waste. So here we are. So it's unfortunate, but
Okay, Holly, in my understanding, it's highly unlikely that we will get 24 trees if we execute where we're going. I will amend my motion to $10,000.
And I'll second the amended motion.
discussion on that motion? Okay.
Actually, I have a question for Mr. Trask. If we do this motion, then can we reduce the fine later if they have, or does he have to go ahead and appeal?
So there's, first of all, once the order is entered, they have 30 days in which to appeal. They would appeal the decision to the circuit court. And there's a whole process to do that. But as for reduction of the fine, anybody can come back before you and ask for a fine reduction at any time. My position would be that that request would have to be within 30 days of the date of the entry of the order. But I don't think the facts are going to change in the next 30 days.
No.
There are additional trees on this property. They said in their testimony that they don't want to take any of those trees down. So if in fact this repeated, it would be a repeat violation, correct?
It really wouldn't matter because the provision of the Florida statute and the code, this is not a repeat violation issue. It's a irreparable and irreversible action. You remember the repeat is up to a $500 a day fine. That would mean that the violation occurred in the day and it came into compliance on the same day. That would be a maximum of $500 on a repeat violation case. So under irreparable and irreversible section of your code and the state statute, that would give you the ability to fine up to $5,000 for total. So there wouldn't be any relation to the number of days that it was in violation. Yeah.
So if they do it again, they come back brand new
It's
and
going to be
it's
the
another
same,
$5,000.
same process as they have gone through tonight. Yeah.
Thank you, Mr. Trask. Any further discussion? No? Okay. Ms. Standy, can you take it to a roll call vote, please?
Beth Cardenas?
Aye.
Carmen Lundy,
Aye.
Holly Myers?
Aye.
Christina Jackson?
Aye.
Jeff Dahl?
Aye.
Tom Shea?
Aye.
Brian Hack?
Aye.
Okay. Motion passes 7-0.
So we're missing one exhibit. I was following the exhibits coming through, we're missing the city's exhibit number 4. Unless one of those pieces of paper that we came through the process should have been numbered number 4. I just want to make sure that we have all the exhibits.
I think I saw 2 number 2 exhibits marked.
Well, there's a number 2, there's the respondents exhibits, 1, 2, and 3.
Yeah.
And then there's the city exhibits, 1 through 9, and I did not see number 4 come through. So The only thing I can think of is that the reference to the city code section may have been
I think they're mismarked.
number 4.
That's fine.
That's what I'm asking, if that should be marked number 4. That's a page that was there that was not numbered. So maybe we'll go ahead and do that as exhibit number 4, and that's the provision of the city code. So I just want to have the record in case, either side needs to appeal this.
Yep.
Okay.
Thank you.
Would you like me to summarize then for the property owner?
Yes, please, Mr. Trask.
Um,
Thank you.
Sir, the Code Enforcement Board has found the property owner in violation of the cited code section and has fined the property owner $10,000 for the 2 violations that have existed. And they've also awarded the city $410 to reimburse the city for prosecution costs. There's going to be a board order that'll be entered within about the next 10 days. Once that board order is entered, it will be provided to you at the address listed, 3911 Dogwood Lane in Ragglesville, Pennsylvania. Is there some other address that you would like it to go to also? Okay. All right, so that's where it's going to be sent, and payment will be due upon the issuance of the order. Okay? All right, thank you. Those are the exhibits from the respondent. We need to make sure they're in there, too. Okay?
Thank you, Mr. Trask. You're free to stay or go at this time. And we're ready for the next case.
Okay, we're gonna go to number 3, under old business compliance hearing. CEB 20-006, City of Safety Harbor versus Jared Burnett, trustee, Burnett Legacy Trust, 910 South Bay Shore Boulevard.
Good evening, my name is Paul Wishy, City of Safety Harbor Code Compliance Officer. This is a compliance hearing. I would like to present the notice of hearing, affidavit of posting, the USPS proof of mailing, the board order, and the affidavit of compliance with board approval.
Any objections? Thank you. The board accepts.
And the respondents are here with your approval. I'd like to speak with you.
We need to have the 2 additionals sworn in.
Yeah, anyone that's going to speak. If you want to speak, you can step forward to the microphone, please. I'm going to go ahead and swear you under oath if you want to speak. It's not necessary for you to speak. Sir, if you could raise your right hand. You swear the testimony you're about to give tonight is going to be the truth, the whole truth, and nothing but the truth? All right, thank you. If you could state your name, please. Okay. Anything you wanted to tell the board? This is a hearing, a compliance hearing, and what the board is going to do is it's going to find your property in compliance. If there's no objection to that from you, the city is pushing that forward. That's correct. No, sir. This will stop any fines running as of the date the property was in compliance, which according to the affidavit of compliance is December 14th.
Do I have the ability to request a reduction or?
You can do whatever you want. You need to get a lawyer probably to help you answer those questions, but you're not going to, you can't do it tonight. It's not been properly agendized. There's no request, written request. Okay?
I guess I would just say thank you for discharging it, and I hope that you discharge it. The city's already hurt my family over $200,000, not including the liens that they have on the property. And so, I appreciate stopping the fine.
That's what they're doing tonight. Okay? There's no other comments, then the board is going to go ahead and make a motion to accept the affidavit of compliance. Ready?
Yeah.
Okay.
Do you understand?
I think so.
Okay.
Yeah.
I
Yeah.
think so. But I would also recommend that either the city, Marcy, Matt Spore be more clear in communication and be willing to have general communication so that we will understand.
This is a volunteer board. They don't control what the city is doing. So if you have a suggestion as to how you want things to happen, you can talk to Mr. Bushy or the city attorney after the meeting, or you can call City Hall and have a conversation, okay? This board is not a, you know, they're the fact finder, okay? They're like a judge and a jury. They're gonna hear your case, and they're gonna hear their case, and they're making a decision. That's all they're doing tonight, okay? Okay.
I'm aware of it, and so I would like to make that statement. I think there's a lot of people on here that were not on the board. When
You don't want them to accept the affidavit of
I would
compliance?
love them to do that.
Okay, well, that's what we're doing tonight. We're not doing anything
I'll
else.
just- I'd love to say a few words.
Okay?
Yes.
Can they accept the affidavit of compliance before I speak?
We would do that after your words, after you speak.
Okay. So just so that people that were not a part of the board know the history before you vote on that. Absolutely. So, because I don't know if they would vote against, you don't know the history of this, maybe you would vote against that, of stopping the fine. So I'd just like to tell my story, kind of, for those of you that were not a part of the board, and sorry if I get a little bit emotional, but my wife and I moved here and bought our dream home in this town because we thought that this was a town that was a lot like where we grew up. And the people operated in the city by the golden rule, cared about the environment and the beautification of the city and all of that. But what I've seen is that this board, maybe when you got here, cares more about policy than actually the environment. Puts policy before people. And so we did not obtain a permit to put a concrete slab by our home for a basketball court for our kids. And we were willing to pay the fines for that. We requested a variance. It was denied. I think it was denied because of not getting a permit. I think we were singled out for that. We spent over $200,000. I have a record of all of it right here. Because when I tried to call the city and say, listen, we've gone to other cities around the country that know, I said, I'll replace the concrete with environmentally friendly court. And I said, can we have a conversation? The city refused to have a conversation, said you need to hire an attorney, we won't talk to you. So I have over $60,000 in attorney's fees. Okay. That we brought an attorney here to the Code Enforcement Board. We brought an environmental expert from the EPA. And I'd like to play a clip of hers. The Code Enforcement Board cut her off because there was probably 5 or 6 people before us, so it was getting late. Everybody wanted to go home. They cut her off. They cut off our attorney. Didn't listen to the facts. I'd like to play a quick video real quick from her that's very brief. So, this is from had come out.
Psychologist of Naylor Environmental Solutions. I've been an environmental consultant in the Tampa Bay area for over 20 years, and my expertise includes wetlands and environmental permitting. I was also previously employed by the Florida Department of Environmental Protection. I've conducted evaluations at Mr. Burnett's property, located at 910 South Bayshore Boulevard in Safety Harbor, Florida, specifically in regards to the basketball court. I facilitated an informal wetland and other surface waters determination, which was issued by the Florida Department of Environmental Protection in July of 2021. Based on this determination by FDEP, the basketball court is located entirely in uplands. Additionally, in coordination with Ms. Carla Berman, who is the FDEP environmental manager at the time of the evaluation and a certified wetland evaluator, the FDEP do not consider any de minimis or remotely related secondary impacts from the basketball court. Their assessment is as follows, quote, as the basketball court has been constructed in upland, toys, debris, trash from entering the adjacent wetlands, replaced and maintained grass area that is removing a source of fertilizer, pesticides, etc., that would run off to the adjacent wetlands, and is small in size, approximately 1,300 square feet, the department would not require additional measures to address potential secondary impacts. Further, I evaluated the structures within the buffer by comparing the former home on site and the new home owned by Mr. Burnett. This evaluation demonstrates that there has been a net reduction of 159 square feet of impervious surface in the wetland buffer. It's my professional opinion and the opinion of FDEP that the basketball court has no impact to the wetlands. It's also my professional opinion that there has been a net improvement within the buffer since the former home was replaced with Mr. Burnett's residence and accessory structures. At 727-207-5525 or anailer@nailerenv.com. And again, this is Abby Naylor, Principal Ecologist of Naylor Environmental Solutions. Thank you.
So that was our expert witness. She further have a letter from Ms. Carla Berman, Environmental Manager of the FDEP, also stating minimal or no damage was ever done to any wetlands, to any mangroves. It was in what was called a buffer zone. And so we actually improved the property for the environment of Safety Harbor. And so, so now we're facing a six-figure lien on our home. We've already spent over $200,000. That includes the construction of the court, the demolition of it, the fences we put up so no toys or basketballs would harm the wetlands or the mangroves. We had to replace the dirt and sod, attorney's fees, mediation. It's interesting to know that the attorney that represented the city of Safety Harbor recently contacted me asking if I needed help because he had sympathy and implied that we were treated unfairly by the city. So, and he was representing the city of Safety Harbor in the mediation. And we paid for that. The DEP, the surveying, all of that. So we asked multiple times, can we sit down, can we figure out a solution? We were never given that opportunity. We've been fined. We have a lien on our home. And so it's cost our family a lot of money. So we're just asking, I guess for this board, that they stop the fine on the property because we've come into compliance. And I would hope, just like the previous person in front of us, that this board going forward, that you guys would see yourselves as civil servants and for the people over policy, and consider that, understand that a lot of the policies are written to protect the environment and the beauty of the city and maintain things. But I think that sometimes there's a spirit of the law versus letter of the law. And I think, and I would think that I hope that everybody here lives in Safety Harbor and we're all neighbors, and you would treat your neighbors the way you would want to be treated. So we're requesting that you all vote to stop fining us because it's hurting our family. And we're not saying we didn't do anything wrong. We should have pulled a permit. And we're willing to pay the fines for that. But we think that everything that's been done since then was egregious and unfair and just not right. And so you guys can vote on that. And I guess we will have to go before City Council to request the removal of the lien and discharge, which Matt Spore stated in mediation that it can be removed once we come to compliance. So, thank you.
A motion to approve affidavit of compliance, please.
I move to accept affidavit of compliance on CEB case 20-006.
Second.
Second motion.
Just understanding and respecting Mr. Burnett, I'd like to do a roll call vote on this one, please.
Beth Cardenas.
Aye.
Carmen Lundy.
Aye.
Holly Myers.
Aye.
Christina Jackson.
Aye.
Jeff Dahl.
Aye.
Tom Shea.
Aye.
Brian Hack.
Aye.
Motion passes 7-0 for the affidavit of compliance. Mr. Trask, would you care to summarize for Mr. Burnett what that means?
Mr. Burnett, the fine has stopped on the case that was cited, CEB 20-006. The fine stopped as of December 14th, 2023. There should be a second order that will be entered reflecting that the property is in compliance, and you should receive that within the next 10 days. Okay?
This is Exhibit 1 for this case, just keeping it all together.
Okay, you ready?
Yes, so at this point, you're free to stay or you're free to go. Your case has concluded. Thank you.
All right, going back up to the top of the compliance hearing, CEB 23-0066, City of Safety Harbor versus 737 Main Street LLC, 737 Main Street.
Does this need to be with number 1?
Yes.
It doesn't have a exhibit number.
Yeah, hang on a second. Paul,
All together,
you need to
okay.
put this with that. Yeah. Thanks.
Okay. Carry on.
Paul, I think they're waiting on you.
We are. Hey, all I got is
Sorry,
time,
yeah.
Paul.
Sorry for the delay. This is a compliance, affidavit of compliance, United States Postal Service proof of mailing and the board order. for the board's approval.
The board accepts.
Just need an affidavit, a motion to accept the affidavit of compliance.
I move to accept the affidavit of compliance.
I'll second.
Okay, Chair recognizes Ms. Cardenas and Mr. Shea as the second. All in favor?
Aye.
Aye. Motion passes 7-0.
CEB 23-0175, City of Safety Harbor versus Samuel K. Harris, 160 Joyce Street.
Evening, my name is Paul Bushy, Community Compliance Officer of the City of Safety Harbor. This is a request for the board to accept the affidavit of compliance. Mentioned case, the city would present the affidavit of compliance, the USPS proof of mailing, the board order, and the lien payment receipt. This was found in the response.
Board accepts. And we'll take a motion.
I move to accept affidavit of compliance in CEB case 23-0175.
Second the motion?
Okay, Chair recognizes Mr. Dahl and Ms. Cardenas for the second. And we'll do all in favor?
Aye.
Okay, motion passes 7-0. Call the next case.
CEB 23-0258, City of Safety Harbor versus Ike Evans, 660 Pine Street.
Good evening, my name is Paul Bushy, Community Compliance Officer for the City of Safety Harbor. This is a request for the board to accept the affidavit of compliance in the aforementioned case. The city would present the board order, the affidavit of compliance, and the USPS proof of mailing with the board's approval.
The board accepts. A motion to approve?
I've got it. I move to approve the affidavit of compliance for CEB case 23-025.
Second?
Second it.
Okay, thank you. Chair recognizes Mr. Dahl and Ms. Cardenas for the second. All in favor?
Aye.
Motion passes 7-0. And then moving down to noncompliance.
CEB 23-0204, City of Safety Harbor versus Paul D. White, 645 Second Avenue North. for non-compliance.
Good evening, my name is Paul Bushy, Community Compliance Officer for the City of Safety Harbor. This is a request for the board to accept the affidavit of non-compliance in the aforementioned case. The city would present the notice of hearing, the notice of hearing, USPS proof of mailing, and the affidavit of posting, along with the affidavit of non-compliance and the board order. There is no respondent present tonight.
Board accepts. And Mr. Bushy, have you been in contact with them? Has anybody reached out?
Oh, yeah, they're, the lien has been satisfied. It's well on its way to having 2 new homes on the property.
So the non-compliance on this one, for what, this is Paul White.
Oh, I'm sorry,
Yeah.
I'm sorry. Thank you.
Yes, yeah. I was like, wait, what?
I'm running a little bit behind.
It's okay.
No, again, there've been multiple attempts to contact this out-of-town property owner and no response at all.
No response yet, okay.
I did check this morning, he has received mailings, but
No dialogue at this point. Okay.
no dialogue.
You curious? Okay, a motion to approve the affidavit of non-compliance, please.
I'll move. I move to approve the affidavit of non-compliance in CEB case 23-0204.
I'll second the motion.
Thank you, Ms. Cardenas. Chair recognizes Mr. Hicks and Ms. Cardenas as the second.
I think it's dull.
Dull. Did I say dull? I'm so sorry.
You said Mr. Hicks.
Oh, Mr. Hicks.
I'm pretty sure my last name
I'm
is
so
dull.
used to Mr. Hicks. Oh, I'm gonna have to get used to that. The other ones I got dull. That's funny.
Close, though.
Close. He'll know that I'm thinking of him. All in
Nobody
favor?
ever called me General Hicks.
Oh, I love it.
First time for everything.
I know. It's so funny. You have to tell him that he's missed. Not roll call vote, all in favor?
Aye.
Motion passes 7-0.
Right, no notes.
Okay, so.
Classic, you owe me for that.
I do. Yeah, you're not gonna let me live it down. No, that's good. So at this point, there's no public input. Board comments, welcome. Thank you for serving. Ms. Marakis?
Yes, thank you very much.
Yes, and so what brought your interest to serving on the board?
So I grew up in Safety Harbor, and was born and pretty much raised here and lived here until I left for college and moved up north for a little bit, and then just recently moved back a couple of years ago and, wanted to really serve the city. I mean, I have very fond memories of growing up here. I mean, it was really the best place. That's why I wanted to live here again when I moved back. So it's a great place.
Welcome.
Welcome, Sylvia. You look forward to serving with you. Thank you so much. Any other board comments? Congratulations to our new vice chair, who is not Mrs. Hicks. Yes, I'll have to get used to that. Miss Myers? Just call you Miss Myers? It's Mrs. Myers? No, Miss Myers. Ms.
Yeah, Ms.
Miss Myers.
I just wanted to make sure everyone got their invitation for the board appreciation ceremony that's happening later this month. And if you haven't RSVP'd, please do so. So hope to see you all there. It'll be fun.
Yeah.
When is it? 'Cause I got,
It's the 30th?
ours said the 3rd. That's why.
Oh,
Oh,
the 30th, yeah.
it's Tuesday the 30th at the community center.
Okay.
I used to be at the library, so I had to double, I was like, oh, yeah.
Yeah, it'll be nice. There'll be more space, so.
Yeah, good. Well, because we're doing construction soon on the library, right? So they're starting to move everything
Yeah,
around.
I just think they wanted a bigger room though.
Yeah.
We were kind of crammed in there last year.
I'm looking forward to it. Mr. Trask, do you have anything?
Nothing, thank you.
Okay, very good. So with that, we will adjourn at 7:54.
Alrighty then.
Because you're married, so like, this is, what do you want?